Today is International Working Women's Day. On this day, we remember the struggles that took place over a century ago when thousands of women workers came to the streets demanding for dignified working conditions, for better pay, shorter working hours, an end to child labor, and a fair share of what was rightfully theirs. It was a demand for equality, it was a demand for liberty, it was a demand for dignity. Today, not only do we remember their struggle, but we must also take a vow to take this struggle forward. As we all know, in a patriarchal structure, women workers face double the exploitation. As women on one hand, as workers on the other. And in this, Dalit women workers face the additional exploitation of caste as well. Through decades of struggle, the rights of women and women workers have been recognized. Certain demands of women workers have been enacted in statute. These rights face a very serious threat today with the coming in of the new Labour Code. The new Labour Code are an assault on the fundamental right to equality that is guaranteed under the Constitution. We must recognize that over 90% of the women workforce are in the unorganized sector. They work under conditions of work that are extremely vulnerable and lead very precarious lives. With the coming in of these new codes, the conditions of these women workers is only going to worsen. Let us see how. Firstly, there is an assault on equality and the right to equal remuneration. Our Constitution guarantees to all equality and prohibits discrimination on the grounds of sex. Article 39D of the Constitution envisages that the state shall direct its policy towards ensuring equal pay for equal work for both men and women. This provision was given teeth to through the Equal Remuneration Act that was brought out in 1976, which was brought out with the objective to provide for the payment of equal remuneration to men and women workers and for the prevention of discrimination on the grounds of sex against women in the matters of employment. This law provides for non-discrimination in the payment of remuneration and in the conditions of service. The new Code of Wages is a direct assault on the same. Firstly, what it does is that it changes the way in which wages is defined, thereby completely watering down the right of equal remuneration. The 1976 law envisages that all remuneration, whether it's payable in cash or in kind, be equal between men and women for the same or similar work. But the new code defines wages to exclude various components that would otherwise have to be there, thereby allowing for gender discrimination. The definition thus excludes any bonus payable, value of any house accommodation, any contribution paid by the employer to any pension or provident fund, any sum payable in the name of special expenses, any commission payable to the employee, any gratuity payable on the termination of employment, retrenchment compensation or other retirement benefits. Thus, by defining wages in this particular way, which excludes several components, it allows for gender discrimination to take place. The second thing that the code does is that it mentions the term employees, which excludes apprentices. Hence, women apprentices do not have the right to equal remuneration. Thirdly, there is a change in the way same work or work of a similar nature is understood. Now, there is an additional condition of same experience that has been included. Importantly, in the context of equal pay for equal work for casual workers, the Supreme Court held this: whether appointments are for temporary periods and the schemes are temporary in nature is irrelevant. Once it is shown that the nature of duties and functions discharged and the work done is similar, and then the doctrine of equal pay for equal work is attracted. So by introducing this additional criteria of experience, this is a clear attempt to deny workers their basic right to equal remuneration. The second aspect that we must see in terms of the assault on the rights of women by these codes is the effect on maternity benefit. While women workers remain entitled to maternity benefit, the manner in which it is defined, the way in which wages is defined to exclude various components would thus result in a far lesser amount being paid. The various components that are left out include conveyance allowance, sum payable in the name of special expenses, house rent allowance, remuneration payable under any award or settlement, overtime allowance, commission payable to the employee, all of which are excluded, and thereby people are in people who get maternity benefits will not be entitled to these aspects. This is another way in which the rights of women face an assault. The next way in which the codes pose a very serious attack on the rights of women workers is by permitting night shifts for women. It deletes the prohibition against employment of women in night shifts in the Occupational Safety, Health and Working Conditions Code and permits employment of women in night shifts. What it says is that it's permitted with their consent. But if we really look behind what this consent, behind this facade of consent, behind this facade of choice, we will see that this simply does not exist. The idea of choice simply does not exist when you're dealing with highly unequal power structures of employer and employee. Can you imagine refusing to work in the night shift and the possible consequences that you may face for such refusal? The Supreme Court in PUDR versus Union of India in 1982, in fact, spoke about something very similar. They say, in a country like India, where there is so much poverty and unemployment, and there is no equality of bargaining power, a contract of service may appear on its face voluntary, but in reality it may be involuntary. Because while entering into the contract, the employee, by reasons of his economically helpless condition, may have been faced with Hobson's choice: either starve or submit to the exploitative terms dictated by the powerful employer. It would be a travesty of justice to hold the employee in such a case to those terms and to compel him to serve the employer, even though he may not wish to do so. This would aggravate the inequality and injustice from which the employee even otherwise suffers on account of his economically disadvantaged position and lends the authority of law to the exploitation of the poor, helpless employee by the economically powerful employer. Thus, the so-called consent taken from women workers to be employed at night would be nothing more than an unfree choice, a complete travesty of justice. The deletion of prohibition against employment in night shifts is thus a blatant exploitative practice against women workers. The next aspect to be seen in terms of the assault on the rights of women is the manner in which the new codes perpetuate bonded labor practice of contractualization. The idea of contractualization, this so-called contract system, is something that has been strongly frowned upon by the courts and has been termed as nothing but bonded labor, nothing but an improved version of bonded labor. And it is this form of bonded labor that is being perpetuated by the labor courts. We must note that large number of women, especially Dalit women, are employed through various forms of are made to work as contract labor, even though they have worked for several decades, and with the fact that these contracts are nothing but a sham, but are only termed as contract workers with the sole intent of denying them their legitimate rights. Large number of Dalit women are employed in caste ordained practices like cleaning of toilets, which are euphemistically called housekeeping staff, and through others in other such works. The Occupational Safety, Health and Working Conditions Code, which solidifies such exploitative practices. This code prohibits the exploitation of contract labor in core activities of any establishment. But while defining core activity, it says that a large number of employments, including housekeeping and laundry services, for example, and says that these don't fall under the definition of core employment, thereby saying that you can go ahead, you can employ workers in this through contract, doesn't matter how long for, doesn't matter what kind of a sham, you can employ them through this. By doing this, it perpetuates both the caste system and patriarchy and grants sanction in law to blatant illegalities. These labor codes, we must note, are being brought in the name of ease of doing business. But if we really look at it, who is at ease and who has to suffer the consequences of this? We must remember the words of Dr. Ambedkar, where he speaks about the idea of liberty in granting in terms of employment. He says that it is true that when the state refrains from intervention, what remains is liberty. But that this does not dispel of the matter. One more question remains to answer. To whom and for who is this liberty? Obviously, this liberty is liberty to the landlord to increase rents, for capitalists to increase hours of work and reduce rates of wages. In other words, what is called liberty from the control of state is another name for the dictatorship of the private employer. What we are seeing today is this opening of the dictatorship of the private employer, which is absolutely necessary to resist. What we see in these labor codes is a blatant violation of the rights of women. Such an attack is a very conscious attack. It is thus necessary that we all stand up against these anti-women, anti-worker codes, not only in terms of the unconstitutionality of these provisions, but also the malefied of the government towards women workers and the fundamental concept of equality itself.